Welcome to Florida's Cannabis News Podcast, a weekly podcast exploring the legal, political, and economic changes to Florida's cannabis industry, covering important news and events for Florida cannabis businesses and professionals. Sit back and relax. Florida's Cannabis News Podcast begins now.
Hey everybody, today is Tuesday, May 12th, 2020, and you're tuned into Florida's Cannabis News Podcast. I'm your host, David, and I started this podcast to create a place to discuss the latest in Florida's cannabis industry. I started the show last year and recorded 10 episodes for 10 weeks. Today, I'm relaunching the show under the same name because if it ain't broke, don't fix it. You can catch the details of the new format on our last episode. But basically, we're going to expand our topics of discussion beyond Florida, if they're relevant, and we're going to release episodes on a more bi-weekly, monthly basis to provide for a deeper conversation. So with that being said, let's get into today's top stories.
The court will now proceed to the fourth and final case on today's docket. Florida Department of Health versus Florigrown, LLC. Counsel?
Today's top story comes out of Tallahassee, where the Florida Supreme Court heard oral arguments for the Florigrown case. Now, if you don't know much about this case, we are now in year 3, and it's a challenge to Florida's vertically integrated medical marijuana market. Florida's medical cannabis market has been dubbed one of the nation's fastest growing and described as an oligopoly, and that's because 13 out of 22 licensed vertically integrated operators operate over 200 dispensaries and to over 300,000 registered patients. We also have well-known multi-state operators who operate in Florida. TRUL CURA Sutera Wellness, Green Peak Innovations, MedMen are all license holders. Investment firms and multi-state operators have also paid millions to acquire Florida medical cannabis licenses. MedMen paid over $50 million to acquire their license. Last month, Cresco Labs nearly struck a deal to acquire VitaCann, one of our active operators in the state, who has 13 retail locations. The all-cash deal was worth upwards of $120 million, but it also included a cultivation and processing facility. These super licenses are what make Florida's medical marijuana market unique. They were created in 2017 during a special session called by Governor Rick Scott. So Florigrown was an applicant for an MMTC license, and they're arguing that not only is the Department of Health not acting properly by not taking applications, but the state enacted an unconstitutional law. Florigrown is asking the court to just look at the plain language of the Constitution versus the statute and show that the legislator changed the words. But as we'll see, the Florida Supreme Court, at least in oral arguments, wanted to take a rational basis test approach to the question and balance the state statute against the amendment Florida voters voted for. Now, just a quick history. Under Amendment 2, which is the constitutional amendment that the Florida voters voted for, which basically started our medical marijuana program. It took everything from a low THC program to MMTCs and the vertically integrated market we have today. Now, there was hundreds of applicants under Amendment 2. In January of 2017, the Department of Health started denying applications or outright not responding to some. In May of that same year, 2017, Florida's legislative session ended without a passage of any legislation relating to implementing Amendment 2. So, in June of that summer, Rick Scott called a special session, and that's where they created these super licenses. Now, Florigrown is arguing, hey, listen, we were fully capable of doing all the tasks you guys asked for in your application, and we applied and had their application registered by the deadline. So Florigrown sued, and at the trial court level, they actually won. The judge issued a temporary injunction requiring the state health officials to begin registering Florigrown as an MMTC, but as fate would have it, the state appealed, and that was put on hold during the appeal. Now, fast forward to July of last year, July 2019, a Florida appellate court, First DCA, First District of Florida Court of Appeal, sided with Florigrown. And when I say the court sided with Florigrown, I mean that they're ruling the statute that was implemented in that special session unconstitutional. After the First DCA sided with Florigrown, the state wanted a full appellate court to revisit the panel's decision. That's called hearing the case en banc. When all of the judges on the court, usually during oral arguments or for any case, it's a 3-judge panel, at least at the appellate court level. The state wanted all of the judges to hear and revisit the case. The appellate court ended up rejecting DeSantis' request to revisit, And there's some pretty awesome language in their denial. So, for example, one of the judges wrote, "The power of the legislator does not include rewriting clear language in the Constitution, transforming a disjunctive or into a conjunctive and." Looking at the amendment, we can see in Amendment 2, the definition of a medical marijuana treatment center lists any entity that acquires, cultivates, possesses, processes, and a laundry list of other things, or administers marijuana, products containing marijuana, related supplies, etc. Now, looking at the law that the legislator implemented in Section 8A of the law, which is Florida Statute 381-986, so they define a medical marijuana treatment center as any entity that has the license to cultivate, process, transport, and dispense cannabis. Continuing on with the rejection from the first DCA to hear the case en banc, because the language is so good, one of the judges wrote, "No evidence exists that the people clearly intended a market limited to only a few fully vertically integrated medical marijuana companies." He's saying it's not what the people voted for. But as we do here on Florida's Cannabis News podcast, we do like to give recognition to the other side, at least for argument's sake. In a sharply worded dissent, one of the judges explained that marijuana remains a Schedule I drug under federal law, which means it has a high potential for abuse as defined under federal law. And he explained that they should have actually revisited the appellate ruling en banc because medical marijuana has a profound impact on public safety. So, after rejecting DeSantis' request, first DCA kicks it up to the Florida Supreme Court, and the main issue in this case is whether our state's vertically integrated system to sell medical marijuana is unconstitutional. And as a result of that, is the court going to break up the vertically integrated system? And we'll talk about the impacts that has on Florida's medical marijuana market soon. Not every case gets heard by the Florida Supreme Court. Now, the Florigrown case falls under the court's discretionary jurisdiction because here we're construing a provision of Florida's Constitution. So remember, the court didn't even have to hear this case, but I think with what's at stake and considering how lucrative Florida's medical cannabis market is, the court heard it. Now, before we dive into what happened last week in front of the Supreme Court, let's talk about the importance of a court ruling one way or another. The court's going to have a far-reaching impact whichever way they decide. We know that licenses have sold for upwards of $50 million, as evidenced by the MedMen license, but the values of those licenses could plummet if the court does away with state caps on the number of medical marijuana operators. Let's say that the vertically integrated market is done with and now Florida is open to a horizontal market. Even if the state issues more licenses, I think the 13 operators, they were first to market, So the question's going to be, was the $53 million, was the X million dollar license acquisition worth being first to market? Probably. I'm not sure. We'll see. Florida's numbers have been solid lately, and we'll see how much that plays into effect if Florida goes horizontal. So, after a 3-year journey, the Florida Supreme Court finally hears oral arguments. So, Florigrown is undefeated right now going into oral arguments. They're 2-0. Things are looking good. We've got great language from the lower courts. And when I first tuned into the teleconference last week, remember, this was the first ever oral arguments held via teleconference for the Florida Supreme Court. So the state, they went first. They were represented by Ron DeSantis' general counsel. But Joe was an awesome orator. He fielded questions well from the judges who were peppering him with questions right from the start. And he argued that the legislator was within their right to implement a vertically integrated system, that nothing in the amendment necessarily required a horizontal model, nor did anything in the amendment make vertical integration invalid. He was essentially making a separation of powers argument.
Mr. Chief Justice, and may it please the court, I'm Joe Jaco with the Governor's Office, representing the Department of Health, and with me today is Daniel Bell for the House of Representatives. I wish to reserve a minute for rebuttal. The order below is a separation of powers concern, when, as here, the statute does not directly conflict with a proper textual interpretation of the amendment. Medical Marijuana Amendment Section 29A sets up an immunity for MMTCs. 29B5 has two conditions for that immunity. First, an entity must be within a larger set of performing one or more of the listed activities. And second, the entity must be in the subset of registered by the department. Then Section 29D calls upon the Department of Health to regulate registration, and 29E invites the legislature to further regulate under its authority. Nothing in the amendment prescribes a horizontal market model, nor does the amendment elbow out the legislature's vertical integration of MMTCs. However, Florigrown makes three mistakes interpreting the amendment for MMTCs on immunity, on registration, and on legislative regulation.
His second argument was the use of the word or versus the word and. Now, he argued that the use of the word or falsely assumes to mean a mandated horizontal market. Again, reiterating the fact that the state was within their right to implement these laws.
First, Florigrown misreads B5's use of the word or on the scope of immunity to falsely assume a mandated horizontal market. Second, Florigrown overlooks B5's registered by the department requirement, on which both the Department of Health and legislative regulation actually operate. And third, Florigrown avoids the amendment's full context on registration, on which there is not just a ministerial duty, but under Section D, MMTCs must be regulated, including with licensure on caps as deemed by the legislature. And as the amendment doesn't address MMTC license caps, there is no direct conflict for this certified question. We ask this court to properly interpret the amendment and overturn the injunction.
Right after the state finished their opening arguments, Justice Muniz fired off questions. Take a listen.
Counsel, can I ask you a question? It seems part of your argument in the briefs, it seems like you want us to interpret the statute the way we would normally interpret a statute in terms of almost this kind of rational basis review, given that, it's an economic regulation. But since the Constitution says that the regulations issued by the department have to be reasonable and they have some kind of goals of the regulations and some of the scope of the regulations here, doesn't that kind of change the nature of our review in the sense that the question for us wouldn't be, or for the court, it seems like would have to involve fact finding, but instead of asking ourselves like we would in a normal case, could a legislature rationally require vertical integration? Instead, it seems like the Constitution would require us to ask, given all the facts that might be presented in an actual, trial, is this in fact a reasonable approach?
Your Honor, while we do think that the statute has a rational basis, the question that's certified to the court is purely a question of whether the statute conflicts with the amendment. And that's just a question of interpretation of the text of the amendment.
I guess my point, though, is that we couldn't really know, because this arguably changes the standard of review, it circumscribes the discretion that the legislature ordinarily would have had. I don't know that we could just say as a matter of law that requiring vertical integration is necessarily reasonable. I'm not saying I agree with the way the first. I think you're right about the way you interpret the definition of MMTC. The amendment doesn't tell you how it needs to be regulated, whether it's vertical or horizontal or whatever. But I guess my question to you, though, is that how could we say as a matter of law that a particular regulation or statute, and I think really the statute you can't have a statute that's unreasonable but in conjunction with a reasonable regulation requirement in the text. So how can we say as a matter of law that this statute is reasonable?
Daniel Bell, in support of the petitioner, raised arguments on behalf of the state, and he was explaining to use a traditional rational basis test. Take a listen.
Mr. Chief Justice, and may it please the court, my name is Daniel Bell, and I'm General Counsel to the Florida House of Representatives, and it's my pleasure to appear today on behalf of the House and in support of the department. I agree with what Mr. Jaco has said today, and I think he's done an excellent job walking us through the text. I'd like to start with the few minutes I have with addressing your concern, Justice Munoz, regarding the potential scope of judicial review in a case like this, and whether the amendment modifies traditional rational basis review. Is that a fair understanding of your question? So first, I'd like to start by saying that in this case, as pleaded in the operative complaint, Florigrown did not argue that the vertical integration requirement was unreasonable. So this issue hasn't been fully briefed. But what I would say is, I think that if anything, the text of the amendment calls for traditional rational basis review, if not for perhaps even curtailed review in this area. And that's for several reasons. First, the phrase reasonable regulations, I think, is a fair textual call out to traditional rational basis review, because of course rational basis review is the familiar standard in which the question is whether the legislature could have reasonably concluded that the law serves a permissible government interest.
Florigrown was up next. Catherine Giddings, on behalf of Ackerman, was representing Florigrown, and she was an awesome orator as well. She cited the law frequently. She answered questions well. She was on point.
Good morning, Your Honors. May it please the court. I'm Kathy Giddings of Ackerman, and I'm here on behalf of Florigrown. Your Honor, I would disagree with several of the things that my opponents have stated, specifically as to the fact that we did not prove that the caps were unreasonable. There was a 2-day evidentiary hearing in this case at which both sides had an opportunity to present evidence, and I'll get into just a second why the caps are in fact unreasonable. So, Justice Muniz, I don't think you need to get into the question of what standard should be applied because it fails the rational basis test. But this case is not about public policy. Your Honors, this court has unanimously and repeatedly said that the legislature can't come in and change the plain language of the Constitution. What the legislature is asking you to do is to allow it to change the words here. If you accept that argument, that means that the legislature could come in and say, under its regulatory authority, that someone would have to have all of the debilitating conditions. It makes no sense. And you look at the plain language, it uses the term or. The legislature has come in and the department was proceeding to have a horizontal system. It was proceeding in following the amendment's dictates, and the legislature came in and said, we control you, we control your funding, and if you do not do what we say, then we're going to withhold your funding. The Constitution, it's easy to determine from the plain text, and I would ask this court to look at Garcia versus Andoni. In Garcia versus Andoni, the legislature tried to do something very similar to what it's doing here regarding the homestead exemption, and this court determined that it could not do so. And if you accept their argument, I would also say that the new amendment governing first responders, this benefits for death benefits for first responders, they could say that a military member doesn't just need to have resided in the state or have been on a post. It would change it to and.
This point that she made, this was more of a secondary point that she made, but this was my favorite one.
But we have record evidence. We submitted 20 affidavits, and you can also look at the triangle brief that shows that even though there are these dispensaries out there, patients who are critically ill cannot get the products they need, and when they can, they are at outrageous prices. Remember, that one of the reasons that the licensing procedure is not appropriate and is not rationally related to any qualifications is that when an entity gets that license, it can immediately turn around and sell it. Today, there are 22 licensed medical marijuana treatment centers. Of those, 12 got their licenses on open market, and they were selling for as much as $50 million. So what you've got is people have these licenses and they're having to make money back. And so what they are doing is they are charging astronomical amounts. Florida, I believe, is up to 4 times more medical marijuana than other states. And the department has never registered one single entity. And remember that if you look at the statute, the legislature, the statute is 27 pages long. We are only attacking a very, very small portion of the statute. And there is a severance provision in that statute. And you will notice that severance provision is only in the Section 8, subsection 8, which governs MMTCs. So the legislature was aware that when it gave these to these closed classes, that it was not going to, that there were going to be questions about this and it might be held unconstitutional.
So I thought both sides were well versed in their arguments. Both parties responded well to the judge's questions. And sometimes, in oral arguments, the judges can put you on the spot and you need to be prepared with what they're looking for. Know your brief, know the case names, etc. So job well done. We will not have an opinion probably from the court 4 months as usual, but in a unique turn of events, the day after oral arguments, the Supreme Court ordered the parties to write supplemental briefs. Now, this was on the court's own motion. They directed the parties to provide supplemental briefs on whether Florigrown is going to have a substantial likelihood of success on the merits of their challenge to the definition of a medical marijuana treatment center in 381.986 8A. In conclusion with this story, the Florigrown case is part of a massive amount of litigation in recent years about how Florida has moved forward with our medical cannabis industry. A lot of the litigation has been surrounded by companies trying to acquire licenses. If the Florida Supreme Court agrees that vertically integrated businesses are unconstitutional, our lucrative medical marijuana market is going to be open up to standalone licensing opportunities. But there is upside to this. We have more competition. It's a more capitalist market. And, it's a good case for legalization. If we have a horizontally integrated market, I think it will normalize cannabis more to the general population. But, yeah, we do need to get rec in Florida at some point. Janelle Taylor out of FloridaPolitics.com takes our second top story of the week and explains that MedMen, a California-based medical marijuana dispensary, multi-state operator, has temporarily closed 5 out of its 8 Florida locations. MedMen has been a topic of conversation on the podcast before and earlier in this episode. We know that they operate in Florida, and they just closed 5 of their 8 locations, Jacksonville Beach, Key West, Orlando, Sarasota, and Tallahassee. They have 3 stores remaining open in Pensacola, St. Petersburg, and West Palm Beach. And according to the company's website, MedMen just explained that, they're temporarily closed effective Sunday, May 3rd. Thanks for your patience. Now, it's not clear, Janelle explains, whether the closures are related to the ongoing COVID-19 pandemic or if there's a deeper problem with the company. A company spokesperson did not immediately respond to a request for a comment. However, the company has been doing well, reportedly, despite the pandemic. According to Politico, the company had its best month in the state in April, with 123,000 ounces of medical cannabis flower sold, which was a 52% increase from January sales before the pandemic hit. But MedMen is also in some financial trouble. The vaping crisis, I think, led to the cannabis capital crunch. And then, we had COVID-19, and This virus is going to kill a bunch of companies. We'll see what happens with them. So thank you, Janelle Taylor out of FloridaPolitics.com. I will have her story linked below in the show notes. The MedMen story segues us seamlessly into our third story of the week, which is the dispensary cap on Florida MMTCs has been lifted. But even though MedMen just closed down their stores, they are just one of the license holders who just received the go-ahead to open as many dispensaries as they want in the state because our cap on dispensary limitations was lifted on April 1st, a month ago. Now, in episode 9, May 10th, 2019 was the date, we discussed how 2 MMTCs got to exceed the state-imposed dispensary cap of 35. Now, even though these 2 MMTCs were able to exceed the state-imposed cap, the state-imposed cap has an expiration date of April 1st, 2020. April 1st, 2020 came around last month, and there's now, on top of being able to sell smokable cannabis, being vertically integrated, now these MMTC super licenses can open an unlimited amount of retail locations. Now, we know Florida medical cannabis licenses have become known as super licenses for 3 reasons. First, vertical integration. It's unique because most states with cannabis programs have a horizontal licensing structure, which means licenses are specific to certain segments of the supply chain. So, for example, in Illinois, you could apply for just a cultivation license or a transport license if you wanted to. In Florida, you don't have that option. Second, there's a limited number of licenses. Today, there's only 22 licenses have been issued and only 13 of them are actively operated. And third, now licensees can open an unlimited amount of retail dispensary locations. Previous to our expiration of the license cap, licensees could open up to 35 dispensaries because there's over 300,000 registered patients in Florida's medical cannabis program. Florida law has a built-in provision explaining that for every 100,000 patients that register for the program, each MMTC can open up 5 more retail dispensary locations. And the law also has a provision saying this expiration, all caps in general, expires on April 1st, 2020. So the expiration of the dispensary cap kind of gives the licensees a boost to expand retail operations and revenue if they wanted to. Now, the licensees have gotten some boosts before. If you don't remember, the repeal and the ban of smokable cannabis gave them a boost because everybody wanted smokable. So it was super effective. More than 22,000 pounds of smokable product were sold in less than 6 months. Now, with the expiration of the dispensary cap, these super licenses have an opportunity to really crush it. But even though the dispensary cap is gone, it did leave scars. Again, this is a theme in Florida's medical cannabis program. The dispensary cap was the spark of much confusion and litigation, resulting in those 2 MMTCs, TRUL and Sutera, to open more than 35 dispensaries, exceeding the state-imposed cap. But license holders like MedMen are not celebrating their new upgrade. After all, this super license status is what attracted multi-state operators to come and purchase Florida licenses. But because most license holders are so tight on capital, they can't afford to just go willy-nilly and open a bunch of retail locations. There's already an ongoing problem of production and keeping quality product on the shelves. So opening dispensaries could put an additional strain, or it would put an additional strain on these production issues. And in addition to that, with COVID-19, a lot of dispensaries went into a delivery model and put their dispensary model kind of on the back burner. And why would you open more retail locations when maybe delivery is the best method at this point in the game? I don't know. But the silver lining to all of these stories is that these issues can be resolved if Florida implements a horizontally integrated market. A horizontally integrated cannabis program would limit cash demands on operating these licenses. It would allow the licensees the ability to be an expert on specific parts of the supply chain. I think it would provide for a new market, a better market, a more diverse market. It'd foster a ton of innovation in products and provide more access to patients, which is the end goal. On the surface, it's the removal of the dispensary cap does give the licensees a quick boost, but to really give a more effective a more effective kickstart to Florida's market as a whole would be to implement a horizontal program. I'm looking forward to seeing what the Supreme Court decides in the Florigrown case. It's going to be monumental, and we will keep you posted here on Florida's Cannabis News Podcast. Hey listeners, so we have all of our news that we cover here on the podcast linked on our Twitter account at FLCannabisPod. Let's continue the conversation on Twitter. That's a place where I like to go and provide micro content, keep the conversation going throughout the week, talk about quick stories and things happening in the cannabis industry. Due to COVID-19, I'm not seeing many cannabis events happening across our state, so we're going to skip the events section and just dive right into this week's weekly patient count from Florida's Office of Medical Marijuana Use. In the May 8th update, the Office of Medical Marijuana reported that 337,552 patients are qualified for our program. I left the link to their weekly update page in the show notes, so you can go on over and click there to see the latest numbers. And that's it for Florida's top cannabis news. If you have any stories or events or people you want to get noticed on the podcast, connect with me on Twitter at FLCannabisPod or email me at david@floridacannabispodcast.com. Consider rating us 5 stars and share with your friends who might be into the podcast. Thank you for staying up to date with Florida's cannabis industry. See you next time.